Now I would like to start this third session of the day, the second session in the afternoon. I would like to welcome our next distinguished speaker, Professor Hamamoto Shotaro. He's a professor at Kyoto University, and he was counsel and advocate for the Japanese government in Welling in the Antarctic at the ICJ, as well as Hoshimaru and Tomimaru at the Ichiro's cases. He has also written extensively in various fields of international law, including arbitration, trade, and all the more. Today, he will discuss about what are called primary and secondary norms of the article on responsible states. Please join me in welcoming Professor Hamamoto as he takes the floor. Thank you, Professor Hamamoto. Floor is yours.
Thank you. Good afternoon. Yes, my name is Hamamoto Shotaro, Professor of International Law at Kyoto University, as you see on the screen. And today I'm supposed to discuss the quite important issue of international law, of course, the state of responsibility, the heart and the core of the international law, in 75 minutes, which is a huge task. And you must be already quite tired after 2 sessions. But this session is followed by Philippa's very stimulating lecture. So if you survive this session, you'll be fine. I'm going to discuss the basic structure of the discussion, the theory of international state responsibility, and pick up a few interesting questions. Start with the what is called ARSIWA, Articles of Responsibility of States for Internationally Wrongful Acts. If you have studied international law, you must have heard of that Articles of Responsibility, which is not a treaty, international treaty, which is not in itself binding document, but which is widely used in the practice. As you see on the screen, the International Court of Justice, for example, in one of the most recent judgments, refers to the Article 30 of the Articles, ILC articles. You have just learned what the ILC is, but the ILC Articles of State Responsibility it represents customary international law, and the same applies to another provision. Article 31. And this kind of expression quite frequently appears in the judgment of the International Court of Justice or other international courts and tribunals. This is another example. Of course, the courts and tribunals do not say that the articles, ILC articles as a whole represent customary international, but specific provisions of those articles may represent or embody or reflect customary international law, and as such, it is widely used. But of course, it is not necessarily always the case, particularly when the states parties, disputing parties, do not agree on the customary nature of specific provisions. Courts and tribunals tend to avoid taking specific positions on that. This is one example. But basically speaking, many of the provisions of the Articles of State Responsibilities are now considered to be part of customary international law. So why is it that Articles on State Responsibility so widely accepted in practice as well as by disputed parties, by courts and tribunals, and by academic writings? First of all, this article simplifies questions, considerably simplifies. Article 1, every internationally wrongful act of a state entails international responsibility of the state. Internationally wrongful act, which means internationally unlawful act under international law entails responsibility. Wrongful act or unlawful act, responsibility. One-to-one relations. It's quite simple. And how is this internationally wrongful act or internationally unlawful act constituted? First, the act must be attributable to the state. That is, must be an act of the state. It must be your act. You are responsible for your act. You are not responsible for any other's act, but you are responsible for your own act. Therefore, it must be your act. The question may be complicated because the state is not a physical entity; it's a conceptual, legal entity. Therefore, it may be complicated. But of course, as a matter of theory, it must be your own act, and it must be unlawful. Unlawful means breach of international obligation. So quite simple. And this constitutes, the distinction between what is called primary rules and secondary rules constitutes the basis of the ILC articles, you may have heard, if you have studied legal philosophy or philosophy of law, you may have heard that different authors use different, secondary rules, primary rules, or tertiary rules in different contexts. Hans Kelsen used this distinction in his own way, and H.L. Hart also used this distinction in his own way. But according to the International Law Commission, primary rules is composed of rights and obligations, and secondary rules comes into play when the primary rules is violated. So the application of secondary rules depends upon the breach of primary rules. First, there's a primary rules. There are primary rules, and when and where they are violated, the secondary rules comes into play, and the rules on responsibility are the secondary rules. You do not have to talk about damage or injury. If you read if you look at the textbook of international law published in 70s or even 1980s, you may find a discussion in the chapter of responsibility that whether the damage or injury, physical, material injury, is a condition for responsibility. There was a discussion, hotly debated, particularly in the first part of the 20th century. But now, that damage question disappeared. Same applies to the fault, the psychological element. Do you need any psychological fault in order to establish responsibility? This touchy question again disappeared because according to the International Law Commission, all those issues are, found in the primary rules. Therefore, they kicked out those questions from the scope of the secondary rules. And now we have very extremely simple rules. Wrongful act, responsibility. And if you breach international obligations, then you commit an international wrongful act. Therefore, you're responsible. This simple structure, simple and clear structure made the Articles of State Responsibility widely accepted by the international community as a whole. And this simple structure is based on some philosophical basis or foundings. First of all, equality of states. This is this difference between the international law and domestic law. This is a very old quote, Charles de Vichy, the Belgian international lawyer, a paper published 100 years ago. At that time, in the first part of the 20th century, states are not necessarily responsible in their domestic law, particularly in the administrative litigations. And if states commit something in domestic law, some wrongs, and incur damage or injury to individuals, states are not necessarily responsible in domestic law. States may be irresponsible. Kings are irresponsible according to domestic law because they are hierarchically superior to individuals. But in international law, already at that time, states are equal. Of course, states are at least considered supposed to be equal. And since they are equal, nobody will impose upon states anything, legally impose anything. But at the same time, if you do something wrong to the others, you are responsible for that. So the equality of states is the foundation of international state responsibility and the international law. And also, there's another quite important international law as of that time, more than 100 years ago, Ancelotti. And if you read this paper, sorry, it's in French, it's almost identical to the ILC, International Law Commission's Articles of State Responsibility. Can you see that? Responsibility is a consequence of a conduct against the law, international rules. So if you breach international rules, you're responsible for that. And unlawful act constitutes two elements. That is, action must be your action and must be a breach of an act. And I refer to this paper, this extremely important article in the history of international law, because Anzalotti says something extremely important here in the second paragraph here. A violation of international legal order committed by a state gives rise to an obligation to reparation, obligation of reparation, which is, in fact, the obligation to re-establish the legal order, troubled legal order. So compensation is required, or reparation. We can use these two words interchangeably, compensation or reparation, are required as a consequence of responsibility or as a substance of responsibility, not necessarily to materially repair the situation, not necessarily to financially repair the situation, but in order to legally restore the situation. The question of the troubled question is the troubled legal order. By an internationally wrongful act, international law breached, international legal order is troubled. Therefore, in order to restore the troubled international legal order, states must do something. This is also the foundation of the international law of state responsibility. And Anzalotti is Italian, and the first special rapporteur in the International Law Commission on State Responsibility was Roberto Ago, also Italian. And so they under the strong influence of Dionizio Anzalotti, who was the president of the Permanent Court of International Justice. Roberto Ago drafted the first part of the article, ILC Articles of State Responsibility. So therefore, the ILC's ARSIWA is based on this philosophy. That's their basic structure. I suppose that many of you are already familiar with the Articles of State Responsibility or state responsibility in general. So I tried to pick up 4 issues of interest. 2 of them are seemingly settled by the text of the Articles of ARSIWA, but in fact not. And 2 other questions are intentionally left unanswered by ARSIWA. So let's tackle the first of them. This is, you see, we have already discussed the distinction between the primary rules and the secondary rules. Primary rules set forth rights and obligations under international law, and when primary rules are breached, secondary rules comes into play, and that's the rules on state responsibility. That's the basic structure. And this distinction was quite useful in order to establish a theory of international state responsibility. The IRC tried to set up a coherent body, coherent text of a state responsibility. They had to identify the question of state responsibility. In order to identify the state responsibility, you have to get rid of all the impure elements. They kicked out all the other elements which are not necessarily related to state responsibility. And this distinction, primary, secondary rules, contributed a lot to that. So thanks to this distinction, introduced by first Roberto Ago, based on the Dionizio Anzalotti's theory, was welcomed by the International Commission. And James Crawford, of course, you know who he is, the last special rapporteur of the state responsibility drafting process, also considered this distinction was essential or indispensable for the theory of state responsibility. Fine, we can distinguish primary rules, secondary rules, at least in theory, and we can say that secondary rules comes into play when primary rules are violated. All right? What happens in practice? In reality? Now, I take an example of a expropriation. You are going to learn international investment law with Professor Tamada, my dear colleague at Kyoto University, who is a real true expert of international investment law. And I'm not going to the details of investment law now. What's important is the distinction between primary and secondary norms. Here we have the text of North American Free Trade Agreement. which is no longer valid today, of course, was replaced by USMCA, CUSMA, or MCUS, or whatever, depending on where you are, new treaty. But anyway, this agreement played a quite important role in the development of international investment law, as well as the development of law of state responsibility. Now, Article 1110, expropriation. Nothing strange here. This is a very banal, ordinary provision. And this kind of provision can be found, as a matter of fact, in 1789 in the Declaration of Rights of People, Rights of Citizens, adopted by in the midst of French Revolution. And you can expropriate. I mean, state can expropriate, but under certain conditions, including compensation. That includes a measure tantamount to nationalization and expropriation, which means that, well, you may be going to learn this in detail with Professor Tamada, but in a nutshell, expropriation means the transfer of the title, legal title of the property. But here, a measure tantamount to nationalization of expropriation may not compose of a transfer of title. You, as a private owner, may continue to hold the title, but you may lose all economic interest rights because of the state measures. State, by taking certain measures, may destroy all of your economic interests. Therefore, even if you continue to hold the legal title of the property, this has become meaningless, economically meaningless. This situation is covered by this provision, a measure tantamount to nationalization and expropriation, which is called indirect expropriation, in opposition to direct expropriation, and that has played also an important role in practice. However, in this kind of situation, in Methanex, the investor was Canadian. And the Canadian investor made an investment in California, in the United States. And the Canadian company produced a material called MTBE, a fuel additive, which California considered harmful to public health. Therefore, Methanex was producing something in California, and that something, MTBE, was later considered by the government of California as harmful to health and the environment. Therefore, the Californian government, without any surprise, introduced a law banning the production of MTBE, which means that Methanex economically has lost everything because they established a factory producing MTBE, and now you cannot sell MTBE in California. Therefore, investment is nothing. It's meaningless. And the company said that, our property got expropriated by the state of California, which is, of course, attributable to the United States. Therefore, they sued the United States of America. Well, if you read this text, Methanex is absolutely right. Absolutely right. Their economic right was completely destroyed. And that was public purpose, of course. That was non-discriminatory fine. But California has never paid compensation. Never paid compensation. Which is quite understandable from the government point of view. They introduced an environmental regulation or health regulation, and they do not have to pay anything, of course. That measure was in order to protect the environment. If you physically expropriate the private property, then you have to pay compensation, of course. For example, if you construct an airport, then you expropriate the land of someone, then you have to pay compensation, even if you did that for the public purpose. But here, the state of California didn't physically expropriate the factory. They simply banned the production. The factory is there, property is there, right? But this property and factory became economically meaningless. Then California refused to pay compensation, which is, of course, not surprising at all. Then what the tribunal said was quite interesting. As a matter of general international law, not as a matter of interpretation of Article 1110 of NAFTA, but as a matter of general international law, a non-discriminatory regulation for public purpose, which is enacted in accordance with due process and which affects inter alia for the investor, is not deemed expropriated and compensable. Isn't it interesting? Because, even if if the measure was for the public purpose and non-discriminatory and the due process, and you don't have to pay compensation. And this is squarely in contradiction with the text of Article 1110. But that's what the General International says. And this, of course, goes along with the common sense. If you introduce the environmental regulation, each time if you have to pay compensation for relevant companies, you cannot do that. You cannot introduce new environmental regulation or new health regulation. Therefore, this conclusion is quite understandable from political point of view. And the tribunal tried to get over this article by referring to general international law. Well, we do not have to get into all the technical details, but what's important here is that theoretically speaking, secondary norms come into play when primary norms is violated. But in this kind of cases, in the case like Methanex, actually, as a matter of fact, there's a political decision by the tribunal that in this case, no compensation is required. There's a conclusion. Well, and then you look at the primary norms. In order to justify this conclusion, you modify primary norms. The tribunal modified the primary norms, which is represented here, by referring to general international law. So you think first about secondary norms, and then you go back to identifying the primary norms. This is what's usually done in this kind of cases. And this solution is not unique to Methanex. This is commonly widely accepted by international tribunals. And this is one of the most important recent examples. Doesn't measure. It's not compensable. Therefore, it's not expropriation. So in theory, distinction between primary and secondary norms are beautifully done. But in practice, primary and secondary norms are interrelated and not entirely separable. Since I put perhaps too many questions, I may be speaking rather fast. And if you have any questions, please do not hesitate to intervene at any point of time by raising of hands or simply speaking out. I'd be happy to respond to your questions or get into these discussions, of course. Second question, attribution. You are responsible for what you have done. You are not responsible for what any others has done, right? You are solely responsible for what you have done. And this is a fundamental position. And you're now looking at the quite important judgment of the International Court of Justice rendered in 2007, already 15 years ago, Yugoslavia genocide question. The fundamental principle governing law of international responsibility is the state is responsible only for its own conduct, that is to say, the conduct of persons acting on whatever basis on its behalf. States are responsible for what they have done. And you may be familiar with these rules if you have looked at the ARSIWA, Articles on Responsibility of States, Article 4, conduct of organs of a state. If an organ of the state does something, it's an act of the state. If a court does something, if a parliament does something, if a Ministry of Foreign Affairs does something, it's an act of state. And the organ of the state is defined by the domestic law of the state. Article 5, if someone is not formally an organ of the state in accordance with the domestic law of that relevant state, nevertheless, the act of such an organ may be attributable to the state, is attributable to the state when those organs are exercising the governmental power or puissance publique. Article 8, conduct of someone, even private persons, may be attributable to the state if the state exercises some control over such persons. Article 11, act of anyone, private persons included, are attributable state if afterwards states recognizes, adopts, admits the action. And among these rules, the most clear, the clearest of the clear is Article 4. Any state organ, that if any state organ does something, it's attributable to the state. It's an act of the state. And the state organ is defined by the domestic law of the state. For example, central bank may be a state organ according to the laws of state A, but it may not be so according to the law of the state B. What is the state organ is determined by the domestic law of each state. So if you look at the domestic law, then you see it. And this is, as Olson say, the most settled and least controversial point. And this comes from a state's inherent power. Even if you do not understand French, you can see it. The word s'auto-organiser. So it's auto-organized. It's organized itself. State has a right to organize itself. States exist before the international law, and international law is constituted on the basis of states which have already existed. And states has a right to auto-organize, and you cannot impose any state how to compose the government, how to compose the judiciary, how to compose the parliament, how to compose the local entities of the government. So it's a matter of each state. So each state decides under its own sovereignty how to organize the state. But there is a price that you have to pay for that. If you define this is the organ of the state, this is a organ of the state, then you have to accept that the act of that organ is attributable to you. If you decide that, for example, the central bank is a state organ, then you have to accept that the act of the central bank is attributable to the state. Fine, so far so good. It's clear. It's, as Alderson said, it's most settled and least controversial. Is it really so in practice? The most difficult question arises here: peacekeeping operations or the United Nations. You know that. In order to maintain peace and order, the Security Council, generally speaking, Security Council, decides to dispatch soldiers. And, for example, if you take an example of the latest example, rather a sad example of Mali, if you visit the website of this mission, you find this kind of sad photo. Comment la MINUSMA ferme ces camps. So how to close the camp. You know, they are now in the process of withdrawing from Mali because Mali decided to let the UN go out of the territory after the government change in Mali. But anyway, if you visit the website of this mission, you get all the documents, all the relevant documents, and you notice that the MINUSMA was established first by the UN Security Council, Resolution 2100, adopted in 2013, which says that the Security Council decides to establish the United Nations multidimensional integrated stabilization mission in Mali, MINUSMA. And this is pursuant to Article 29 of the UN Charter, which entitles the Security Council to establish subsidiary organs. Therefore, each mission dispatched to the ground is a subsidiary organ of the Security Council, according to the UN Charter, Article 29. Right? Now, you need soldiers, of course, because it's a peacekeeping operations. And according to the website, the MINUSMA has now 1,167 676 soldiers. Who are they? Who are they? I mean, the United Nations has no armed forces. You know, that there has been no agreement concluded in accordance with Article 43 of the UN Charter, and the United Nations United Nations as an international organization does not have its own armed forces. Therefore, they need the contributing states. I mean, they need the member states contributing armed forces to those kind of missions. And now here, in the case of MINUSMA, we have 53 states contributing forces, including Germany, Australia, Austria, etc., etc. So those countries are sending their armed forces to Mali under the framework, in the framework of MINUSMA mission, of UN mission. So what's the stage, or what the status? What is the status of those soldiers? But they are soldiers of those states, right? But at the same time, they are working in the framework of MINUSMA. What's the status? According to the United Nations Secretariat, this is the Secretariat document. This is the structure of command and control. First, Security Council has the ultimate control. This, it is the Security Council which decides to establish a mission. Therefore, the Security Council is on the top. The Security Council asks or empowers the Secretary General to do concrete jobs, to establish the forces. And the Secretary General organizes forces. At the end, it's not clear, I'm sorry, military units, civilian units, police units, etc. So military units are contributed to by member states. And they are under the control of component heads, military component heads, which is responsible to the Secretary General and then to the Security Council. So they are under the control of the United Nations. According to the Secretariat, once assigned under UN operational control, contingent commanders meaning the commanders of these units, the smallest units. The small units are composed of soldiers of the same state. For example, the Dutch contingent, or Benin contingent, or South African contingent. Those contingent has its own commanders, of course, small commanders, commander of a small group. Those contingent commanders and personnel report to the force commander here, and they should not act on national direction. So if you have South African soldiers dispatched to the UN mission, you are, of course, South African soldiers, but you are working in the framework of this mission. So once you start working in this framework, you cannot receive a direction from your government. You are solely responsible to the superior of the United Nations, ultimately the Security Council. That said, of course, they are soldiers of their state. Now, General Assembly resolutions, member states of the United Nations officials to express mission, appropriate action. Well, and this is a resolution almost annually adopted by the General Assembly. Now, the serious question concerning the peacekeeping operation is the sexual assault, sexual abuse committed by the members, by the soldiers of the UN peacekeeping operations. Not by the so-called enemies, but by the UN itself, UN members itself. That's a very, very serious question. And here, the UN General Assembly says that commitment of the UN Secretary General to refer credible allegations of sexual exploitation and abuse to the member state. What does this mean? What does this mean? If there is an allegation that a certain member, certain soldier of the UN peacekeeping operations committed the sexual abuse or sexual exploitation, then what can we do? The point is that the United Nations has no criminal court There is an international criminal court in The Hague, but of course they are not there to deal with this kind of questions, right? So there's no criminal court, criminal tribunal within the United Nations. Therefore, the Secretary General refers to the member states, to the stage of the soldier, for them to take certain appropriate actions. So criminal actions must be carried out, conducted in the stage of nationality of the soldier, or in the stage of the contributing state. In the contributing state, UN can do nothing, which means that even if the UN soldiers are under the command, under control of the United Nations, they are still under certain control of the state, because criminally speaking, it is the contributing state which is responsible. And another document which you are looking at with the English translation is one of the Japanese statute, the Japanese legislation, which is applicable to the treatment, which is about treatment of personnel of the Ministry of Defense. And this is also applicable to the members of the self-defense forces. And by the way, for the non-Japanese participants, you may have heard that Japan has no, constitutionally speaking, we have no armies. But international-wise, we do have armed forces. If you are interested in this kind of constitutional delicacy, ask any of the Japanese participants. They'll be very delighted to explain this interesting question. But anyway, international-wise, this is a domestic question, because Article 4 of the ARSIWA says that it is the domestic law which determines the status of the state organ. Although an official of the Ministry of Defense dispatched to international organization, for example, UN, still retains the status of an official. So if you go to the United Nations, if you go to the peace mission, you retain the status of the official of the Japanese government. That's a matter of course, right? What happens then? Article 4, if something was done by this organ of the state, is attributed to the state. Therefore, if a soldier dispatched to the peace mission does something wrong, this act is attributable to the contributing state, right? To the state, according to ARSIWA Article 4. But we have another set of responsibility, rules on responsibility, this time articles on responsibility of international organizations, 10 years later, adopted by the same International Law Commission, which says that in Article 7, conduct of an organ of a state of the organ of the agent that is placed at the disposal of another international organization shall be considered under international law an act of the latter organization, if the organization exercises effective control. Therefore, thinking about this, taking into consideration of this structure, the act of soldiers are attributable to the United Nations. Perhaps, if the UN exercises effective control, what do you mean by effective control? But anyway, if the UN exercises effective control, there is some contradiction already here, but there is more interesting and important question. When the International Law Commission proposed this text, the Secretariat of the United Nations sent a document vehemently criticizing the International Law Commission. So the UN organ criticizes another UN organ, which is a very interesting situation. According to the UN Secretariat, that Article 7 is fine in other contexts. So we support this article in other contexts. But as far as peace operations are concerned, we cannot accept this. That's the position of the Secretariat. When it comes to the peace operations, regardless of whether the control exercise of all aspects of operation was in fact effective. So effective control is not a question. When it comes to the peace operations, always acts of soldiers are attributable to the UN. Even if UN exercises no effective control by it, always attributable to the United Nations. for a number of reasons, interestingly, notably political reasons, not the legal reasons. The reason is not legal, but for political reasons, acts of soldiers are attributable states. Legally speaking, this article is fine. We can support this article in other courts. That's fine. Legally speaking, that's all right. But for political reasons, as far as peace operations are concerned, we cannot accept this. What are those political reasons? This was already said 50 years ago. If acts of soldiers are attributable to the contributing states, not to the United Nations, but to the states, what should happen then? What happened? If, suppose that Malaysia sends soldiers to a peace mission, and those soldiers do something, and those acts of soldiers are attributable to Malaysia, and Malaysia is considered to be responsible for that, what would happen? Then it was feared that the states will refuse to participate in peace operations. You are contributing your soldiers for good cause, for the peace and order of the international society. And you have to be responsible for that. You have to perhaps pay compensation for something. And that's ridiculous from the viewpoint of sending a state. We are contributing to the United Nations, we are contributing to the international community, and we have to pay compensation for that. What is that? Then the states will refuse to participate in peace operations. Therefore, we cannot accept that kind of situation. Secondly, if, to the contrary, they accept nevertheless to send their soldiers, states will certainly require a complete control over their soldiers. Because the acts of soldiers are attributable to states. Then states must control them. Otherwise, they will have to be responsible for something over which they have no control. That's not politically acceptable. Therefore, if acts of soldiers are considered to be attributable to the states, states will certainly require a control over the UN's peacekeeping operations, which is, of course, inimical to the independence and impartiality of the UN peace operations if, each soldiers are under the control of the contributing state. Therefore, it's not acceptable. So political reasons, it's not acceptable. But there's something else. The structure of the UN budget. UN budget is divided into, basically speaking, into two parts, regular budget and the peace budget. And this is about the peace budget. Who are the contributing states? Level A, P5. P5 together, 58%, right? Germany, Japan put together, those 7 countries occupied basically 75% of the peace budget. So seven countries take care of 75% of the peace budget, which is not surprising, which is decided by the General Assembly. That's fine. What about the soldiers? The soldiers are coming from these states. This is taken from the UN website. Bangladesh, Nepal, India, Rwanda, Pakistan, Ghana, Indonesia, etc., etc. There's a clear disparity between the contributors and the payers, which is good in a sense, because this is kind of made intentional. Big states, influential states, do not send soldiers, with the exception of China, do not send soldiers in order to maintain the independence and the impartiality of the UN peace operations. If, for example, the United States sends tens of thousands of soldiers in UN peace operations, that operation will not be considered to be independent and impartial, right? So since the UN peace operations are composed of those soldiers, the operations' neutrality, independence, impartiality are considered to be guaranteed. But seeing from another point of view, but this may represent some neo-colonialist structure of international community, whether we, the people, the rich people, people of the rich country are sitting in the air-controlled room, air-conditioned room, sitting on the couch, looking at the TV, watching the news of the peace operations. On the other side of the screen, poor peoples of poor countries are hardworking on the ground. So this may represent a neo-colonialist structure of the international community. But anyway, the reality is this: payers and workers are different, right? The result is this. Again, quite normal. If you send more soldiers, there are more chance of sexual abuse or exploitation. South Africa, Cameroon, Gabon, Democratic Republic of the Congo, Morocco, Tanzania, Burundi, Senegal, etc., etc. Those countries, the soldiers of those countries are considered to have committed sexual exploitation and abuse in a number of cases. If the United Nations is responsible for the acts of soldiers, UN soldiers, what will happen then? It is the United Nations who has to pay compensation. But in reality, who are required to pay compensation for that? If the budget of peace operations is composed like this, 75% of compensation will be paid by P5, Germany, Japan, right? When the sexual assault or exploitations are committed by those soldiers. There may be something politically unacceptable here, but also legally speaking, it's a bit difficult to accept this because, what's the function of reparation? One of the functions of reparation is deterrence, future deterrence. If you are required to pay compensation or reparation of what you have done, you will think that you will never do it again, right? Because you will, again, have to pay compensation for that. But in this kind of situation, those countries will not pay compensation. Therefore, if the United Nations is supposed to pay compensation or reparation, there will be no deterrent effect on the soldiers or on the states. But it's unrealistic, completely unrealistic, to oblige those states to pay reparation and compensation for that. And that has also counter effect. We have already seen that. Those countries will then, in that kind of cases, they will refuse to send soldiers, and then UN peacekeeping operations will not be possible. So we have a, kind of catch-22 situation where this difficult question remains. To make matters even worse, there's a question of immunity. Even if the UN is considered to be responsible, there is no proceedings within the United Nations. We have seen that there's no criminal tribunals in the United Nations, but there's no civil tribunals in the United Nations either. You know that there's an administrative tribunal for UN civil servants, but not for soldiers. The United Nations is required to establish a dispute settlement procedure of private law character, but the UN has not complied with this provision for almost 80 years. United Nations, as an international organization, has not complied with this obligation. There's no proceeding established within the United Nations. Therefore, since there's no legal proceedings, there can be no legal proceedings within the United Nations. You may wish to, if you are a victim, you may wish to go to some domestic court to sue the United Nations. But in that case, of course, the questions of immunity arise. You're going to learn immunity in the next session. And the tribunal will certainly refuse to listen to you. This is one of the most recent examples of the judgment of the United States Court, federal court. The court says that even if the United Nations does not comply with obligations under Section 29, there is an immunity pursuant to Section 2 shall be recognized. Therefore, the U.S. tribunal has no power to hear the case. So there are multiple reasons, multiple problems here. There is one recent, very, I would say, strange development in the Netherlands. In the Belgium also, we have similar judgment. This is the Supreme Court judgment 2019. Already the Dutch Supreme Court adopted a similar position in 2013. You may have heard that the massacre of Srebrenica in Yugoslavia, and the Dutch forces were involved in that. And the Dutch government, Dutch Supreme Court recognized some part of responsibility, they say 10% of responsibility in the massacre of Srebrenica, because they exercised 10% of control over their armed forces, which was working in the framework of UNPROFOR, which was a mission, peace mission dispatched to the former Yugoslavia. This solution may be interesting, at least the victims or legal heirs of victims can obtain certain amount of compensation from the Netherlands, so that's fine, but there are some problems. Of course, we have this kind of problem. The states may refuse to participate in peace missions. The states may require even more control over the peace operations, but their forces working in the framework of the peace operations. And this solution is possible, of course, because it is the Netherlands, rich country who can pay for compensation. But you cannot imagine that those countries will be ready to do the same in reality. Therefore, this looks like a beautiful story, but in reality, it's not. Well, I have no miracle solution on this. If you do, you become a star of international law. You write a paper and publish in certain journals. Anyway, seemingly settled and least controversial Article 4 contains, in fact, a very serious problem, which is hidden, but very real questions. Let's go to other sets of questions. The International Law Commission considered that there were clearly established distinction between primary and secondary rules, and there's no question of attribution regarding Article 4, and we have seen that there are, in fact, questions behind those clear rules. But here, now, there are at least two issues, with respect to which the International Law Commission itself recognized that there remain some problems, the question, unsettled issues. What kind of issues? First, the reparation. The reparation rules may look, again, quite simple and clear. Full reparation, Article 31, full, means wipe out all the consequences of an illegal act. All the consequences, and you have to wipe out all the consequences of the illegal act. This is a famous quote from the judgment of the Permanent Court of International Justice, factory at Hojuf, rendered in 2019. 2019, 28, almost 100 years ago. 100 years ago. I don't know how many times this phrase was quoted, perhaps more, certainly more than 100 by the international courts and tribunals. And this continues today. This is one of the most recent judgments of the International Court of Justice. Again, full reparation. Stop. Fine. Okay, you have to wipe out all the consequences of the illegal act. In order to restore the legal situation, you have to wipe out all the consequences of the illegal act. Simple enough, fair enough, fine. But the question, according to the International Law Commission, remains with regard to private parties. Private parties. What do you mean by what do they mean by that? Article 33(2). This part, including compensation, reparation, is without prejudice to any right arising from the international responsibility of a state, which may accrue directly to any person or entity other than a state. other than the state. Therefore, the reparation rules apply to state-to-state relations, but not necessarily to the private person-state relations. That's a matter of primary rules according to the ILC, which is a bit difficult to understand. But if you go to the investment arbitration, which of course you're going to learn on Friday, usually tribunals simply quote a factory hojov, wipe out all the consequences. Simply they repeat. Some perspicacious tribunals refer to Article 33(2), which says that it's not necessarily applicable to private party-state relations. But the tribunal says that although they say that, it is generally accepted that the IC articles can be transposed to the content of investor-state disputes, that is, private party-state disputes. So they simply copy the rules to the private party-state relations. It is all right. Perhaps, yes, in normal situations. But what if this? What about this? This one recent arbitral award, Titian versus Pakistan, again, we do not have to go into the details. Simply the conclusion, the Pakistan is obliged to pay compensation of this amount. Not a petty amount, right? $4 billion $4 billion compensation. What's interesting, or what's intriguing is that the date is important. Sorry, the date is important. Remember the date. 12th July 2019, right? July 2019. Same year, July 3rd, 10 days before the award, the IMF announced that they make an emergency loan to Pakistan for its financial crisis, right? 6 billion, right? So the IMF decided to loan $6 billion for emergency reasons to Pakistan, and 10 days later, the Pakistan has to pay $4 billion to an investor. So what shall we do? Well, this is a consequence of full reparation. Well, Pakistan is required to pay because it committed internationally wrongful act. Well, what's wrong with that? I mean, they did something wrong, and they are required to pay full compensation, the result of this. But this happens in the midst of its financial crisis, and that was not their unilateral allegation. The international organization, such an international organization as IMF, decided to make a loan, emergency loan, to Pakistan to the amount of $6 billion. So naturally, the Pakistan argued that no, we cannot pay this amount. If you do that, you have to remove, you have to cease fund the health, social welfare programs. We cannot pay for hospital. We cannot pay for primary schools, etc., etc. Therefore, this amount is ridiculous. The question is, so what shall we do in this kind of situation? In fact, the International Law Commission, in the process of drafting the relevant provisions of reparation, discussed this issue. Full reparation is the principle, that's fine. But in a case where the state which committed an internationally wrongful act has serious limited financial resources, we may have to think about something else. We have to, or generally speaking, you have to wipe out all the consequences of illegal act. But if you have limited financial resources, first of all, you cannot do that. So therefore, some legal rules may be necessary. There was a discussion conducted within the International Commission. So one idea was that in no case shall reparation result in depriving the population of a state of its means of subsistence. And that kind of proposal was made in the process of drafting. Right? But this was not welcomed by states, interestingly enough. Of course, I mean, there was a kind of interesting discussion in the Sixth Committee or in relation to the International Law Commission. Look at this. France said, no such limitation is accepted. No limitation. Germany, yeah, full reparation is required. It's under international full reparation is the principle. But when it comes to war reparations, maybe the situation is kind of different. Perhaps in the case of war reparation, there could be some limitations, of course. We all know what happened 100 years ago. France, no, full compensation. Germany, well, in case of war, the story may be different. But that's basically the only debate. The United States, of course, never will accept that kind of limitation, full compensation, full stop. One delegate from Chile stated compensation should never have the effect of depriving the population of a state of its means of subsistence. But I think that she is almost the only example. It's very difficult to find any other states which stated in line of this argument. Therefore, this argument was rejected in the International Law Commission. And now we have the current text, full reparation, wipe out all consequences, no exception. That's theoretically speaking understandable. Theoretically speaking, that's understandable. As James Crawford, the special rapporteur, states that maybe states have limited financial resources, but it's not the fault of the victim. It's not the fault of the victim. Victim is entitled to receive full compensation. You states may have some limited financial problems, some financial problems, but it's not the fault of the victim of the unlawful act. So victim is entitled to full compensation. We have to think about this kind of issue in another context, such as lump sum agreement. What do you think of this kind of situation? Well, we can think of adopting some special rules concerning state to private party relations. For example, you say that, well, in the case of state-to-state relations, full compensation must be needed. But in relation to private parties, it is ridiculous to pay this amount of compensation to private parties when the state is receiving this amount of aid, emergency aid. Well, yes, that may be the case, but what about this? Diallo, you may have heard of this recent judgment of the International Court of Justice. This is a case between Guinea and Guinean investor and the Democratic Republic of the Congo. This case went before the International Court of Justice, not to the investment tribunals, because there was no investment treaty between Guinea and DRC. So by exercising the right of diplomatic protection, the Guinea sued DRC before the International Court of Justice, and the International Court of Justice rendered this judgment. They found some illegal, unlawful activities on the side of DRC and obliged to pay compensation. Therefore, indemnity corresponding to the damage, which means, of course, wipe out all consequences, right? Wipe out all consequences on unlawful act. This is a simple and direct application of the rules embodied in Article 31, compensation, that is full compensation. It's a state-to-state relations, Guinea-DRC relations, state-to-state, full compensation, no problem. But what's the difference between this and Tetian versus Pakistan? That the similar case, investor had a problem with the state, host state, and in Tetian, Pakistan, the investor decided to go to investment tribunals because it was available in that specific case. But here, Mr. Diallo was not able to go to the investment tribunal because it was not available, simply it was not available. Therefore, they asked the government of Guinea to intervene, and the government accepted, and then they went to the International Court of Justice. So this is state-to-state relations in the formal sense, but in reality, it's a private-to-state relations, right? It is typical to the diplomatic protection cases, and this is no exception for that. Therefore, it's a bit difficult to establish the rules, only exceptional rules, only applicable to private parties. Perhaps we have to go deeper into the problem and think about the possible limit to this principle of full compensation, full reparation. And this is a complete review, a reversal of the principle. Therefore, it will be extremely difficult. But this kind of question occurs quite frequently. We have to think about that. If you're interested in, I strongly recommend to read an interesting paper written by Papalinskis, my friend Papalinskis, and which I put in reference. Also, you may find in the reference an article written by someone called Hamamoto, which is also dealt with a question similar to that. And also, you may be interested in reading that. Final question, touch also as difficult as the others, the countermeasures. What's the countermeasures? Some states commit internationally wrongful act, unlawful act. The victim state, which is called the injured state, may take some measures against the author state, the state which committed original international wrongful act. And that act reaction may be justified as countermeasures. If the original act of unlawful is unlawful under international law, and if you're a victim, and you may be able to take unlawful act in reaction to that in order to restore the previous situation. Who is the injured state or the victim state? Of course, if the state is injured individually, or if the unlawful act is addressed to a group of states, if you are specially affected, you are victim state. Fine, general. But if you are not victim state, what can you do? The ARSIWA contains a long article, 48, what non-injured state can do. But there, you find no countermeasure. In the list, you find no countermeasure. So you cannot take countermeasure in light of Article 48. But Article 54 has an interesting provision. This chapter does not prejudice the right of any state, which means that any state includes, of course, non-victim or non-injured state. They can take lawful measures. What lawful measures? Does it include countermeasures? This ambiguous provision was included because of the lack of consensus. This question of the possibility of countermeasures taken by a third state, that is non-victim state, was hotly discussed in the International Commission on the 6th Committee of the General Assembly, and there was no consensus emerged. Therefore, the International Law Commission decided to include this ambiguous question in order to show that they intentionally leave the question open. And this question arises and arising today. Here, of course, I do not represent the Japanese government. I'm not speaking on behalf of the Japanese government, so my speech is not attributable to the Japanese government. And maybe the government may say something different, but my understanding is that if you visit the website of the Japanese government, the Ministry of Foreign Affairs, you see this, they're taking measures against Russia, for example, assets freeze. Assets freeze, what do you mean by that? Restriction on payment, restriction on capital transactions. So if you cannot send money from Japan to Russia, for example. Russian investor in Japan cannot send their money from Japan to Russia. And this is squarely against the text of the Japan-Russia investment treaty, investment agreement, free transfers. Free transfer, no restriction. And, well, in exceptional situations, you can take some restrictive measures, but, you look at this, financial and economic circumstances. So this exception applies only in cases of financial crisis, not current situation. And this BIT investment treaty contains no essential security interest clause, no security exceptions. Therefore, it's extremely difficult to justify what the Japanese government is doing within the text, within the BIT. Is it possible for the Japanese government to take countermeasures against Russia? Russia is not invading Japan. Russia is invading Ukraine. Japan is not a victim state. Is not specifically affected by it. It is of course generally affected by any other states, like Brazil, Argentina, or New Zealand, which are on the other side of the planet. But Japan is not specifically affected. Therefore, in light of Article 48, Japan may not be able to take countermeasures, but the question is open in Article 54. Is it justified to do this? Not only Japan, but many states are taking. Some consider that since there are many states taking this kind of measures, like the United States, European Union, Japan, Australia, Canada, New Zealand, whatnot, are taking measures against Russia, now there is a new customary international law emerged. In this kind of situation, in the situation of aggression, the aggressive nature of the Russian invasion is recognized by the UN General Assembly, resolution of the UN General Assembly, and under this kind of exceptional situations, countermeasures is recognized. But some say that no, it's not. There's no such customary international law because look at the text. Nobody, including the European Union here, Japan or any others, says they do not say that they're taking those kinds of measures as countermeasures. Nobody is saying that they are taking these kind of financial restrictions or financial sanctions as countermeasures. Since they do not describe these measures as countermeasures, there's no opinion juris. Therefore, no customary international law emerged. Others say that, well, formally speaking, you may be right. But they do not say, in the absence of specific indications, well, certainly they do not say, but what's important is what they do. Therefore, now we can consider that the customary international has already emerged, that now we can take countermeasures. The countermeasures is justified on the customary international law. Seen from another point of view, rather political, my friend Caro Focarelli states that, well, you may consider that this is a beautiful story, but the measures taken by what is called the international community, in fact, taken by a few hegemons called the United States, the European Union, Japan, and therefore it's a pure, bare conflict between superpowers and not the matter of international law. So those kind of measures cannot be justified and under international law. This is a rather sober description or understanding of the situation, but certainly there is this kind of problem. The fundamental problem of countermeasures is that the state which is taking countermeasure decides that you are committing international wrongful act. This is on the basis of this unilateral decision, the countermeasures are taken. But the other side of the coin is also true that if you accept the Focarelli's argument and the hegemon should not do anything, then you simply accept, which means that you simply accept what the Russians are doing now. Is it right under international law? Is it correct? So this political fight, political understanding is, disagreement is behind this difficult Article 54 of the Articles of International Commission. Now we have come to the end of the session, at least of my speech. Sorry for speaking so fast, so 75 minutes. And if I'm allowed to take any questions, you are invited to do so.